You are now listening to Comp Corner, brought to you by the law offices of Bradford and Barthel.
Welcome back to Comp Corner, the podcast where workers' compensation strategy meets real-world execution. I'm your host, Nasir F. Adil. Let's jump in. Today's episode applies for CE credit. It applies for up to 30 minutes of CE credit. Please see the show notes for information on CE credits. In the show notes, you can find the link to the CE credit form or send an email to compcorner@bradfordbarthel.com for a link to the CE credit. Today's episode is a continuing education style deep dive featuring Amir F. Adil. Amir and I discuss the strategic components of the alternative dispute resolution, or ADR, med-legal process. We discuss hurdles in the ADR process, including who is causing the hurdles. We talk about the benefits of ADR jurisdiction and the ombudsperson's role in the process. We address document production, and Amir and I finish with a few war stories and give practical tips when handling your own ADR file. Big Comp Corner thank you to our CE episode guest, Mr. Amir F. Adil. Amir is an equity partner and managing partner of business research, development, and sustainability here at Bradford and Barthel. Amir is also a returning guest to Comp Corner, as he was our very first guest on our very first episode, numero uno, back in January 2025. Welcome back, big brother Amir.
Hello.
Well, we're happy to have you back on specifically to address the ADR med-legal QME process. How are you doing, sir?
I'm good. What's going on? I've been enjoying the podcast.
We appreciate the support from you as well as all of our loyal listeners. So what are the issues with the ADR med-legal process in your opinion?
You know, I have to start by saying I really enjoy litigating in the ADR program. I find it is refreshing. I find it's more entertaining almost at times. I don't know if entertaining is the right word there, but I think it's just more conducive to fleshing out the litigation. It also throws back often to the pre-SB 899 world, right? The old AME QME days, as we used, or the AME QME dance, as we used to call it back then. So I do enjoy the litigation, but what are the issues? Some of the issues that I see are stemming from a total lack of awareness on how to litigate in the system by opposing counsel. Obviously, I'm a defense attorney, so I only see the applicant attorneys as opposing counsel. They, I'm sure, will have their own interpretation on what are the issues and where they're coming from. But I think a part of the problem stems from failing to read the rules. Right? If you don't read 4060 Labor Code sections 4060 through 4062.2, 4062.3, you don't know how to do the AME QME process under the state act, under the WCAB system. So if you don't bother to read the rules in the ADR program you find yourself in, then obviously you're going to have a problem in litigating in the ADR program. And that I think is where a lot of the issues are stemming from.
No, we appreciate that. I think back on our episode, we had Michael Peabody, who is the director of our ADR program. We were lucky enough to have him on, and we talked about, hey, the med-legal process. The first thing that people and attorneys who are not familiar with the ADR program that they're in, they don't know what to do. You know, they don't know what to do, and oftentimes they'll reach out to the defense attorney, and you're like, look, first thing you do is literally read the ADR rules. They're not going to be as thick as the labor code. They're not going to have hundreds or thousands of pages. It's usually going to be, what would you say, 5 to 8 pages about all the ADR rules?
I remember his answer in that podcast, and I remember smiling to myself and kind of internally screaming, yes, of course, read the rules, right? Why would a lawyer need to read the rules? But
Right.
that's literally the answer in a lot of these issues where in one program, I don't want to name programs, but in one
Yeah.
program, the applicant attorney or attorneys will often email me or call me and say, "Hey, how do I do this?
Mm.
I'm sorry, I'm not going to tell you how to litigate against me." And
Right.
before they've even called me or emailed me, the first thing that program often does is
Mm.
that ombudsperson will email, fax, and mail a copy of the rules to the applicant attorney, who promptly ignores them.
Yeah. Right.
So if
Yeah.
you're not going to read the rules, then of course you're going to have questions.
Yeah. And these rules are simple. There's, 4 to 6, maybe 8 pages, and they're so simple. Like Michael Scott always taught us back in the office, keep it simple, right? We'll ignore the other S, but they really are simple, and we don't need to complicate the ADR process. And once that attorney on the other side uh, understands that, they're like, oh, that's it's all right there. So literally reading the rules are uh, they solve 99% of the headache and the problem that go forward. So, Amir, who is causing the hurdles in your opinion as far as the ADR QME process?
I think I don't want to say exactly who is causing the problems. I'll talk about what the problems are, right?
Okay,
Because
right.
in our system, as you know, what's good for the goose is not good for the gander, as you know. And when it comes to workers' compensation, I find that the defense is constantly, we're the devil's advocate. And the injured
Sure.
workers and the applicant attorneys are the priests in the right church or at the right venue. So the other side always has this aura of being correct, even when they're not correct. And we always are defending every single thing. But one thing I notice is maybe we can break this down into three different categories. Often
Sure.
I see applicant attorneys do not understand or they misunderstand that they can unilaterally designate a QME thinking, oh, it's ADR. This is like the old pre
Mm,
SB 899 world. It's going to
right.
be dueling QMEs. And they just designate a doctor and schedule an appointment, which may be fine in one or two of the programs or
Right.
some of the
Right.
programs, but that's not the process in a few other programs. And we can talk about the kind of the different programs and, or at least the categories that the different programs use. But one of the problems is unilaterally setting an evaluation
Sure.
without reading the rules.
Yeah, I think like back to basics, right? Knowing the rules. I mean, the bottom line here, the key practice tip
Mhm.
for our listeners is knowing the ADR rules. Okay. I keep on saying that because every program, guess what, has different rules. Some have competing QMEs. That does take place sometimes. Some programs exist where the ombudsperson goes out and selects that panel for you. That exists too. Some allow AMEs. Some aren't necessarily in love with AMEs, but it's not that complicated, but the only complication is making sure that you understand those rules and understanding that you can't just let alone get your own panel either. Some programs might let you go ahead and get a panel from the DWC, but if you do that unilaterally without knowing the rules, guess what? You got to go back to square one.
Yeah.
So that's really helpful for all of us. Thank you.
No, that's exactly it. Those are kind of the three categories, right? Some programs allow you to unilaterally select, but even in those programs, you got to have done some version of the old AME QME dance where you issue an objection letter, you offer an AME,
Yeah. Yeah.
even if that AME is ridiculous, you offer an AME.
Right. Right. Right.
I offer
Right.
Dr. Seuss, Dr. Dre, Dr. Pepper. Those are I've always wanted to use Dr. Pepper as an AME. Um, so you offer somebody and then you schedule an applicant QME or a defense QME. So that's one way. But that process is inappropriately
Yeah.
imported into the other two or three category of ADR programs. And to flesh out what you were saying a second ago, at least one of the other programs has it where the ombudsperson selects the QME. And so I can ask for, I want specialty A, and applicant attorney can say, I want specialty B, but the ombudsperson is going to choose whatever the ombudsperson likes or designates or thinks is appropriate.
Right.
And if we disagree with that, then we go off into mediation land.
Sure.
Yeah.
Sure.
And the third one requires a little bit more understanding of the rules. So
nuance. Yeah.
A little bit more nuance. I like that. It's a big word.
So with your understanding and about the ADR, different ADR programs out there, what are the hurdles you face? Some war stories, some practical hurdles that you face every day as far as just the ADR QME medical legal process?
One of the problems is more an irritation and an issue for, okay, how do I do this so I'm not teaching my opposition how to litigate against me?
Right.
And how do I do this so I'm obviously not turning into a bigger hurdle than the other side is, right? I find our system is kind of goofy in that, because it is workers' compensation. Applicant attorneys, even judges in both systems. By both, I mean at the WCAB level and in the ADR level or jurisdictions. They want defense to help out the other side.
Sure.
I'm in favor of that. Injured workers didn't ask to be injured. They need benefits. They get benefits. Our job is to get them benefits. But the frustrating part for me is when the other side calls me up, emails me up and says, "Hey, how do I get a QME?"
Right.
You don't have that opportunity in family court. I can't call up the other side's lawyer and go, "Hey, how do I get my client alimony?"
Right.
The public defender can't call up the DA and say, "Hey, how do I get my client off?" What? You got to read the rules. You got to figure that out, sunshine. And then the condescending emails or the voicemails back. Well, defense is not helping us get our QME. Excuse me?
Yeah.
So, but then again, the other part of the answer was, I also don't want to become a bigger hurdle, right? I do need to, you need to assess and go, okay, does my client owe alimony?
Right.
Yes, probably. I got to have this conversation with my client where I say, okay, they do have a right to a med legal. So I go into prevent defense. I have to prevent them from going down the wrong track.
Sure.
If we're in a system where the ombudsperson unilaterally gets to select, then I need to flag the issue for the ombudsperson and my client and the other side and say, hey, opposing counsel, you have self-designated an applicant QME. I don't think that's the right thing to do here. And before you call me up, or because you called me up or emailed me and asked me what the right thing to do is, I'm going to involve the ombudsperson to my prevent defense, right? And if I'm wrong, the ombudsperson can jump in and say, no, Amir, you're wrong. We're going to afford an applicant QME. Wonderful. If that's what you want to do, okay. But if that's not what you want to do, and 99.9% of the time, the ombudsperson comes in and says, yeah, you can't do that. You don't get to unilaterally designate. Then the ombudsperson will usually start to educate the other side.
There we go. Yeah.
So I played prevent defense, right? I prevented you from going down the wrong thing. I didn't teach you how to do it, but I kind of cornered you into the right process.
And that's usually where the aha moment is for a lot of AAs, where at first they're like, this ADR program, it's pro defense only, the CBA, the collectively bargain agreement, this, that, blah, blah. And then once they learn about the rules and an issue comes up and you're like, look, you can't file a declaration of readiness to proceed to get us to the WCAB. If there's a treatment issue, TD issue, that just ain't it. But you know what? I have a good solution for you. That's contacting the ombudsman. And the ombudsman, send them an email if there's a TD or treatment issue. Guess what? You don't have to wait 3 months, 3 weeks, 3 years to get on calendar. You get a response from the ombudsperson, usually that same day or the day after. Guess what? That issue, that gets that treatment or TD issue then gets nipped in the bud. And that aha moment is like, oh, this ADR program can be effective. It's actually designed, it's working exactly how it was designed to be beneficial to not the employer only, but also to the injured worker. And then everyone's like, oh, sheesh, this actually is a very efficient process. So, any other hurdles, Mr. Adil, as far as you face war stories that you have in mind, as far as just the med legal process and just being a part of the whole advising of the process, not only to your client, but also to the opposing counsel and the ombudsperson?
Oh, yeah, sure. Gosh, there's several more things that come up. One or two things mercifully have stopped, by which I mean, I don't know what happened. I want to say sometime around 2017, maybe it was 16, maybe it was 18, but sometime in the mid to late teens, certainly by the late teens, I feel like some memo went out
Hmm.
to the WCJs at the WCAB that said, stop fighting every ADR program. Stop
Yeah,
insisting on having some supervisory role to every ADR jurisdictional case.
right.
Let those cases go. If there's an issue, the recon unit is there as the supervisory level. So, what am I blathering on about? Sometimes, if there
Right.
was an issue in ADR, the applicant attorney didn't like the answer, they would just file a DOR.
Right.
It was, no, I'm still going to the WCAB. I've conceded to the ADR jurisdiction,
Yeah.
but I still know exactly where the WCAB is located. The clerks there are nice. The judges are very applicant friendly. I'm going to go there. So, then we're in concurrent jurisdiction land. I'm disputing jurisdiction, but there we are anyway at the WCAB. And then the judge there is arguing with me about an ADR set of rules that she also hasn't read.
Sure. Sure. Sure.
And we're setting the issue for trial with the ombudsperson from the ADR program as my witness A to educate the WCAB about rules that are not before them. So anyway, sometime
Yeah.
around, I think, the mid to late teens, that nonsense stopped, and the ombudsperson became really the real
Mm.
referee, helpful referee, or guidepost maybe is a better way to say it. Another set of issues that um, I see come up from time to time in different programs is who's going to actually write the cover letter? Are there dueling
Yeah.
cover
Yeah.
letters? Is there one cover letter, as they use more often in Southern
Yeah.
California, as arguably the code used to say was required? Who produces the records? That kind of
Yeah.
stuff.
Yeah. That's very helpful. And we're going to get into that shortly. I think as far as you mentioned dismissals and the WCAB versus the ADR
Hmm.
jurisdiction, again, we touched base with this on the Michael Peabody episode,
Hmm.
but I am really happy and relieved that judges do not really fight any issues with dismissal requests. And the practice tip here, whether you're a claims examiner, defense attorney, or even an applicant attorney, is if you're if you know you have an ADR file with ADR venue, then practice tip is go ahead and file that petition for dismissal from the WCAB. Yes, put that in your ADR settlement document. Always put that in your language as far as a stip or compromise and release, having both parties agree that the WCAB case is dismissed. But as those who are listening know, when an ADR file is brought up, usually there's also a WCAB ADJ number, just because the applicant attorney doesn't realize that they filed the application. So defense attorney claims, file that petition for dismissal. It's a very short one. If you need any help, feel free to reach out to your attorneys here at Bradford and Barthel. But once that's filed, as long as you put in the standard language about including the MOA or the CBA or whatever, WCJs they're okay with it as long as you justify it. Guess what? You'll usually get that order back dismissing the case within a
Hmm.
few days. So that's a very good practice tip that we definitely want to keep in mind.
Did you know Bradford and Barthel has free monthly workers' compensation webinars that provide CE and MCLE credits? Topics have included soup to nuts, such as calculating TD and PD, applying the AMA guides, defense tips for drafting CNRs and STIPs, taking effective doctor depositions, and many more. Register to attend a live event, or you can review over 100 accredited hours of recorded webinars on our training page at bradfordbarthel.com.
So one thing you mentioned, which was great, Amir, you mentioned the ombudsman's role. So can you tell the listeners what role the ombudsperson plays in an ADR claim?
That's where I was kind of struggling. Are they really a referee? Because they don't make any decisions, but they kind of do say, "Hey, knock this off," or "Hey, you can't do that," or "Hey, go look at this part of the law." So they're a guidepost, maybe. Maybe they're a mom or a dad or kind of a help desk or the information and assistance officer. They play some different version of these roles in the process, but I found them usually to be they're usually a help.
Right.
So in a different context, I remember the program there has an MPN, but basically the MPN is everyone who's also in the group health. Because again,
Mm,
this is ADR programs are under the bigger umbrella of a CBA, a collectively bargained agreement between the union and the employer or the set of employers. And in that CBA, they've also agreed to group health. Without naming health insurance companies, they chose health insurance company A. So
mhm,
all of the union members have Insurance Co. as their health insurer. Every doctor who is a provider in Insurance Co. is also an MPN doctor. So the injured worker there was having trouble getting someone authorized. And I think the applicant attorney, maybe it was the injured worker himself, but someone from the applicant side emailed the ombudsperson and said, I can't find an MPN doctor. And the ombudsperson quickly emailed back and said, well, it's everyone in your group health.
mhm. Right.
Oh, and it was an instant answer. Like 17 minutes later or shortly after that email, the applicant attorney said, oh, wonderful. We didn't know that.
Boom.
Done.
Resolved. Resolved.
Now, as opposed to them writing me a letter threatening sanctions if I don't get an MPN authorized, I need you to go and get your MPN access coordinator involved. We're going to
Sure.
subpoena your adjuster to an expedited hearing. The adjuster is crying because now she's got to find home health care for her loved one she's taking care of. The supervisor's mad. It's madness sometimes at the
Oh, yeah.
WCAB level, right?
Oh, yeah.
A simple email, solved the problem.
And everyone wins, right? The applicant wins, the defense wins with that. It's issue resolved, on to the next one.
100%. I don't like getting those emails. Oh, well, I'm going to subpoena your adjuster unless you
Oh, yeah.
authorize someone in the end. I bill $9 million an hour. All right, calm
Yeah.
down.
Right. Right.
A simple,
Yeah.
hey, can you help me find a doctor? Usually takes care of it from the defense side. But the ombudsperson involved, where he or she knows exactly the right answer,
Yeah.
because that's what they do as well. Oh,
Yeah. Boom. Brilliant.
fantastic.
Yeah,
Yeah.
that's the magic elixir right there. And um, to your point, I think the ombudsman's roles vary, as we all know. It depends not just like how every ADR venue is different. Same thing with ombudspersons. Some are much more hands-on, where they know the system inside out. They'll reach out to you. They'll reach out to AA. Some are more, laid back. They're like, well, you all figure it out. Here's the general framework. Let me know when you need me, which is fine too. But the person is there to facilitate. They're there to really help out both sides. And the best person that guess what? They are someone who communicates with both sides and
Mhm.
keeps everyone on the same page. So, very helpful stuff.
I
Amir, you
like that.
mentioned
Facilitator, new noun. I'm going to use that. You asked me the question. I meant to say they're a facilitator.
there we go. No, they're like again, old school point guards, right? Or old school, just they're not out there trying to get 40 points a night, but they're out there trying to make sure that everyone else eats. They're dishing out passes.
Yeah.
They're the ones making sure that everyone else gets their stuff taken care of. So, excellent stuff, Amir. Thank you. So you mentioned before about document production. What about document production? Who is producing the cover letters as far as most ADR programs go?
So I don't know, but I'll
Yeah,
tell you the three different brackets that I think encompass, they encompass my experience. In one set of programs, it really is the old AME, QME process, right?
sure,
You issue the
sure.
objection, you offer an AME, maybe you don't offer an AME. Again, my favorite are Dr. Pepper. Dr. Dre. But in those programs, each party is writing their own cover letter to their own doctor. It's kind of quiet. You don't tell the other side about it, and you produce your own records. And then in that set of ADR programs, you kind of open up to their records review page like we used to 20 years ago and say, okay, what did you read to formulate your opinion? Oh, you didn't have this set of records. Wonderful. That's an additional reason why I'm going to say the applicant QME report. Or if I'm an applicant attorney, they're going, oh, this is an additional reason why the other side's QME report is deficient because they were missing this record or this set of records or this test or whatever consultation report. So again, in one set, each party is doing their own cover letters, their own document production. In a second set of programs, the ombudsperson is really taking the lead. They designate the doctor, they schedule the appointment, they send the appointment notices, they'll even send out their own cover letter, and sometimes that program will say, hey, defense, you send out the records, or they will send them out. And then each party in that program can write their own cover letter if they want or supplement as indicated. But the ombudsperson is really the quarterback running everything. Yeah. And in the third set of programs, it's a hybrid where it's dueling QMEs. But in that program, that in my mind, defense is the repository for all records. So it's up to me as the defense attorney to get documents over to the applicant's QME. I don't choose the QME. You have to go through the process. But once they've designated a QME going through that process and set an appointment, I will just write a very simple cover letter that says, Dear Doc, applicant has chosen you as their QME. Enclosed find the medical records. Have a lovely afternoon. And I'll put in a declaration, right? The med legal declaration. And I produce the records. Now, the applicant attorney there in that program, that third category, can write whatever advocacy letter they choose, and they usually do not copy me. Similarly, in that program, I do not copy the applicant attorney. I just tell them, here's the 997 pages I'm going to produce. I'm going to write my advocacy letter. Let me know if you object. You're not going to get a copy of my advocacy letter. Have a wonderful afternoon.
Right.
That's it.
No, that's very practical knowledge for all of us. And that gets us back to square one. If you know your rules of that ADR program, you not only know who the QME is, but you also know his or her, how we can contact them, right? Most programs allow you to even contact, if you're a defense, you could contact applicants QME, like Amir was saying. You can send them a cover letter. Just make sure you CC both sides. And that's fine to do. I frankly pick Michael Peabody's brain a lot, or even Janine Lewis, who's one of our ADR liaisons, because you want to make sure that you're not doing any ex parte communication. But knowing the rules is often the first and the most easy place to learn the process, and then go from there. And then you realize, again, it's all about efficiency. Get the report, get it back. Once you get the report back, guess what? You don't have to wait 6 months to get on calendar. You get the report, other side gets the report. All of a sudden, you're in settlement land the next couple weeks right after that, if not a few days, right?
So I don't normally write the other side's doctor in the first category where it's dueling QMEs. It's just in that third category where the program has it, where the defense attorney or the defense is the repository, that I'll write them a very simple, hey, here's the records. Applicant scheduled you for an eval. Have a wonderful afternoon. I'm not going to say the applicant is or is not injured. We dispute this or we admit that. Hey, look at this for a PNS. Hey, look at that for work restrictions. Hey, look at this for a return to work. I'm not writing an advocacy letter per se in that third one. I'll do the advocacy letter really almost only in the first category as they exist in my mind, where you have dueling QMEs. I normally do not contact the applicant QME in the one where there is a dueling.
Sure. Fair. Now, circling back, when we first started, you mentioned why you like working with ADR files. And we've talked about some of the benefits already, right? Just efficiency. getting to the chase, resolving issues, and just closing files out. But what are some of your opinions as to why you like working with ADR files?
It's that facilitator, man. I'm going to steal your
Yeah.
word, your noun.
Word of the day.
Because the applicant attorney sends me an email, hey, you've chosen, we've designated Dr. Goofball as a treater, right? Located at Pill Mill Hill, USA.
Right.
And you didn't authorize. So I'll just email them back. Hey, where'd you find this doctor? They're not in the MPN. Well, if you don't authorize them, then I'm going to subpoena your adjuster and we're going to an expedited hearing. In this back and forth, I'm copying the ombudsperson, and the ombudsperson will say, hey, I looked in the MPN. This doctor's not in there. Choose somebody else. Stop threatening people with litigation that doesn't exist. Knock it off.
Yeah, stop filing your labor code, your 5813 and 5814 penalty petitions. Just save that pleading for later. Let's get back to the issue, how it can be resolved, right?
So why do I like the program? Because you have this instant referee, you have this instant facilitator, you can carbon copy and say, okay, you think I'm wrong. Got it. Hey, Ms. Ombudsperson, what's the right thing to do here? And like you said earlier, you'll get an instant response in the matter of minutes or hours. Rarely is it more than a day or two that the ombudsperson takes to get back to you. So it moves the case. It moves the file. You disagree with us on treatment? Bango, you got an answer. You disagree with us on the QME? Bango, you got an answer. Very little threats, very little wait. We don't have to wait for days to get down to the WCAB. You don't have to get yelled at by a judge.
Right. No, we appreciate that wisdom. Now, finally, talking about practice tips. Practice tips I always tell people is, look, first and foremost, read the rules. We've mentioned that multiple times today. Secondly, file for dismissal. Okay, I always say, look, after that, you got to make sure you can contact the ombudsperson. They're there to facilitate. Word of the day. But please read the rules before you contact the ombudsperson. We're all big boys and big girls here, everyone. You don't go to the principal without knowing what the issue is first, right? So know the rules. What other practice tips do you have for the listeners, claims, attorneys, whoever, as far as handling ADR files?
I think that the dismissal is got to be either the first or one of the first steps, and I see that often missed by not at this firm anymore, but I saw that many times when I've taken over files. Why is there still a WCAB case in Ames that's not dismissed?
Right.
There's not even a petition on file for dismissal, so that's one of the first things I think you got to do. Another practice pointer is, like you said, read the rules. I also want to say fall within the jurisdiction, by which I mean, just like you're going to follow the rules in the program for getting a QME, subpoena records using the ADR case number.
Yeah.
I often see that the case has been dismissed, but the subpoenas from the other side are still using an ADJ number.
Right.
Just bad form. Why are you using a dismissed case's jurisdiction to order records in the ADR program? The ADR program has its own case number. Use it.
Yeah, as we say here on Comp Corner, the best file is a closed file, but to get a closed file, you need to be organized, and that's why organization is everything, whether it's WCAB or ADR. But Amir, you've been amazing today. Thank you for all your help and wisdom guiding us through the ADR medical legal QME process. We hope to have you back soon.
Thanks for having me.
That wraps up today's CE session on Comp Corner. The key takeaway: strategy is not reactive, it's intentional. The more deliberate you are with documentation, medical analyses, and timing, the more control you maintain over the life of the claim. Check the show notes for sending your Comp Corner questions. Thank yous to Amir Riabi and Tammy Welty for producing this episode. Of course, thanks to Big Brother Amir F. Adil for joining us. We appreciate you for joining us on Comp Corner. We'll see you next time.